Good morning, everybody. All right, so I'm Tom O'Connell. I'm a board member on your chamber, and I am the chairman of Aspiria 2034. I normally am spending my time up here, but when I'm not up here, I am down at Best and Krieger working with these two fine gentlemen here. First, you're going to hear from Joe Ortiz. He is one of our partners at our firm, labor and employment attorney, and is an absolute expert on topic of marijuana. What you're going to have the opportunity to do today is to, well, hold on, not that type of expert, right? Well, yeah, no, I heard 420 and you started giggling, so I don't know. Now, Joe is going to be going through this slide presentation, and at the end of this, we understand everybody's schedules are just as compact as you can have it. So if you want to stick around for questions, please do. We're going to have about 30 minutes of Q&A. If you need to run, I don't fault you. We all have busy lives and busy businesses. So as soon as he's done with that, we'll give everybody a couple of minutes. If you want to stick around, great. If you don't, take off. We won't fault you. At the end of this also, we have Victor Ponto. He's an attorney at our firm and is a rising star. He's a senior associate in our municipal group. He's been working with these laws for our cities for, gosh, over a year now. So if there's somebody that's going to know things about how this is going to affect what our city is going to work like, it's going to be Vic. So with that, I'm going to turn this over to Joe because we have a quite compact presentation. Hope you all enjoy.
Thanks, Tom. Hey, who wants to learn about pot? Everybody? Okay, so first, yes, I'm a partner with the Labor and Employment Practice Group with Best and Krieger. That means labor and employment's all I do. I was joking, when they talked about 420, I'm like, I get calls every day, and it amazes me because the employers call me and they'll say, my guy's, yeah, I think he's high. What can I do? I'm like, test him right now. You can, let me start off by saying you can still test and you can still prohibit marijuana usage and possession in the workplace. And we're gonna get to that in more depth. And I also want to thank Victor for being here today. He's one of the individuals who helps craft these ordinances for the cities. So we figured to the extent that you have questions about the exact city ordinances and how it interplays, I can pick on him. So I can go, Victor, you take it. So we're going to go today. We're going to talk about Proposition 64. And by the way, I will say this, Best and Krieger has done this by a webinar in a longer format, so there's a 2-hour format. We have a PowerPoint presentation. You can look at it at our website, which is bbklaw.com, or you email Tom or me and we'll make sure you can get a copy of the PowerPoint presentation. So if you're looking for specifics, there's a lot of information we've jam-packed in here. We're going to go through generally the marijuana laws first, so I'm going to give you kind of a thumbnail sketch of medical marijuana, the laws that govern that, a thumbnail sketch of Proposition 64 and what the cities are allowed to do, and then we're going to get into the meat of it. We're going to talk about employment law and what you have to worry about and where the potential areas are for change. We're also going to touch a little bit on, potentially what the federal government, because we have a new administration, and what they might be doing. So let's go ahead without further ado and kind of talk about the marijuana trends. So medical cannabis is currently legal in 26 states. So it's a huge trend. The majority of our states are now allowing it. So we've got recreational cannabis in Alaska, California, Colorado, Maine, Massachusetts, Nevada, Oregon. It's early in the morning, guys. I haven't had my third cup of coffee yet. I promise I have not had any marijuana. Oregon, Washington, and Washington, D.C. Okay, so let's go through the federal laws briefly. A lot of people forget that the reason why states are allowed to go ahead and regulate and allow some marijuana usage is because of the federal government under the Obama administration took a hands-off position on marijuana law. Now, they didn't change the law, so that's really interesting. But what we have here is the Department of Justice under the Cole memo in 2013 basically said, okay, we're going to focus on these 8 issues, and otherwise, if the states want it to be legal, we're not going to interfere. So we're basically going to focus only on preventing distribution to minors, preventing revenue sales from going to criminal enterprises such as gangs and cartels, preventing the diversion of marijuana from states where it's legal under the law to states where it's not legal, preventing state-authorized marijuana activity from being used as a cover or pretext for trafficking other illegal drugs, so smuggling methamphetamines or heroin or something like that, preventing violence and the use of firearms in cultivation and distribution, preventing drug driving, preventing the growing of marijuana on public lands, so BLM lands will still be enforced, preventing marijuana possessions or use on federal property. So that's basically all the DOJ, the federal government, said that they were really concerned of Otherwise, they were saying, we're gonna kick it over to the states, and what the states decide is what we're gonna allow to occur. But just be cognizant of this, because this makes all the difference. It is still technically controlled and illegal under federal law. So we've got a really unusual circumstance, because usually federal leads the way and the states basically follow. In this circumstance, the states are leading the way, and the federal is basically saying, we're still illegal, we're still saying it's illegal, but we're not really gonna enforce. At least for now, because the next item is, we know Jeff Sessions. We have elected Attorney General Jeff Sessions, who's been a vocal opponent to marijuana legalization, and it really would only take a pen stroke for him under the new administration to say, now we're not going to allow states to do their own thing anymore, and that would be a game changer. So you can be certain that if that occurs, you will have another presentation, I'm sure, right away. It's more business for us, right, Tom? Okay, California law. Let's talk about California law first, and I'm going to give you a thumbnail sketch. I hear the term MRSA, and I always think staph infection. No, MRSA, the Medical Marijuana Regulation and Safety Act, or MMRSA. That's medical marijuana. So there were 3 bills, AB 243, AB 266, SB 643. They created a robust regulation system for medical marijuana. Now let's kind of go through this. I always thought it was funny, Senate Bill is 420 right there. But 1996, you probably recall, because I recall, getting those calls and trying to figure out what's going on with medical marijuana. Prop 215 is another term for the Compassionate Use Act, so you probably have heard that term as well. It provides protections for seriously ill persons who have their doctor's recommendation. So it's supposed to be for a doctor's recommendation for a medical issue. Now, look, I'll take the position, I'm an employer-side labor and employment attorney, so I've seen, at least anecdotally, a lot of the cases where this has been abused, where people are going in and the employee comes back and we're saying, you have a medical marijuana card, but for what? Well, my back or stress, or basically, if you can walk off the boardwalk in Venice Avenue, or Venice Boardwalk, and get a medical marijuana card, I kind of question its medical acumen, if you will. So also provides protections for physicians or primary caregivers who assist these seriously ill persons who are known as qualified patients under SB 420. SB 420 required the California Department of Public Health, so I'm kind of jumping because I want to go through quickly, to create the medical marijuana program, and that's where we get the medical marijuana identification cards. So those are not prescriptions, those are medical marijuana identification cards. It also created the Bureau of Medical Cannabis Regulation within the Department of Consumer Affairs. Licenses were to be issued by 2018, so we're really coming up on that, and allows local taxation and regulatory license fees. Now, if you ask me, what it seems is that the pro-marijuana groups have actually taken an incremental approach to the legalization of cannabis or marijuana. So we did medical marijuana first. Now we do recreational marijuana, but you'll see the recreational marijuana is somewhat limited. They basically have carved out the areas where conservative groups or employer groups, chambers of commerce, have taken the position where, hey, we're concerned about this. So they've actually allowed areas where those groups, so for instance for us, employers can still enforce our zero tolerance policies. So medical marijuana, it allowed, when medical marijuana came through, it allowed the local governments to ban outright medical marijuana dispensaries, medical marijuana delivery services originating or terminating in the jurisdiction, medical marijuana cultivation, medical marijuana manufacture, testing, and other medical marijuana uses. So when you see those green plus signs, we can still regulate those, and in fact, that's what Victor has done. So if you want to pick on him for questions, please feel free to raise your hand. And by the way, I'm okay. I think it's more interesting if there's questions, so if you have questions, feel free to raise your hand, and we can go through as the presentation is moving forward too. So now let's talk about what we're here for today, which is Prop 64, or recreational marijuana. I've heard people say AUMA, but my tongue gets tied when I say it, so I'll say Prop 64. It passed November 8th, 2016, and it legalizes recreational use of marijuana by adults in California. That's 21 and older, and it was effective November 2016. So what does it do? Basically, if you were 21 years or older, you can possess up to 28.5 grams of cannabis plant material or 8 grams of concentrate. Indoor cultivation of up to 6 plants for personal use inside a private residence or accessory structure, and possession of any marijuana plants produced by those plants. Now, 6 plants is a lot. Okay, go ahead.
What would be considered concentrate?
I'm gonna kick that to Victor.
So the typical way to imagine concentrate is what they do now is when they're manufacturing marijuana, instead of using the plant product, they take the oil extract out of the product, and then what they'll do is they sell it, the little oil cartridges which are used with vape pens. So rather than walking around with the plant, you have the oil derivative thing.
So it'd be like a vape pen version?
Exactly,
Okay.
exactly.
And does that apply to like tincture too?
I'm sorry?
I said, does that apply to like tincture as well? I have
Tincture?
tincture is like
Like a glycerin base.
Right, with the oil in it.
Sure, that's right. And it applies to edibles too, so if you have an edible extract, like say a gummy bear or something like that, they also infuse the oil in these things so you can consume it.
How do you know they make gummy bears?
So they make Jolly Ranchers and brownies and everything else. Yeah, it's now.
He means from what he's heard,
From what I
they make gummy bears. And that's one thing we're going to get toward at the end, is that testing is really kind of in its infancy. In other words, there aren't a lot of tests, there's tests about how recently you've smoked, but as far as calibrating the THC in your system, my understanding is that those tests are still in process. They really aren't there yet. Right now, our tests mainly say whether you have it in your system or whether you don't. Okay, so there's going to be a state excise tax of 15% on medical and recreational marijuana, cultivation tax of $9.25 on flower, $2.75 on non-flower plants, and it creates Division 10 of the Business and Professions Codes to license marijuana businesses.
Question,
Yeah, of course.
when does that go into effect and where does that money go?
We just had this question, right? We had a person from the state franchise. I believe it's supposed to go to programs, correct?
That's right. So I have a slide here in one of my former presentations. So what they're gonna do is they're gonna take that 15%, 60% of that will go to youth programs, substance abuse education, prevention and treatment, 20% to environmental cleanup and remediation, and then you've got another 20% to reduce DUIs, reduce negative health impacts regarding marijuana legalization. And then if you permit commercial cultivation, local agencies also are allowed to get additional money to fund for crime prevention. But if you completely ban commercial use, then you do not get that money to local. And it goes into effect with these regs, the deadline or the goal is January 1st, 2018.
One more in the back.
Just to reiterate, the taxes will only be collected once the local governments issue the permits. The state cannot collect unless you have a local government permit, correct?
That's right.
That's correct, and we're looking at 2018 as the year where we're supposed to have all these regulations in place. And again, that is presuming that Attorney General Jeff Sessions on the federal side doesn't, throw a cluster bomb into the whole thing and squirrel it up, because he says on the federal side we're going to start enforcing now. So we'll see what happens there. So, but let's talk about what was carved out of Proposition 64. So the local governments are still allowed to ban recreational retailers, medical dispensaries, any delivery service originating from or terminating in the jurisdiction, outside cultivation, so outdoors, and any other state licensed marijuana business licensed under Division 10. And also, here's the important issue: the city cannot ban personal use in the private residence. Although I have seen, I think the city of Fontana just passed a law where they said if you're living in an apartment complex, you have to get I believe, a notarized statement from your landlord saying that it is allowed. So you might see some issues like that come up. And the city can ban use of marijuana in all other contexts, including use in public spaces, on-site use at dispensaries or retailers, or use in any public space within 1,000 feet of school, park, or other public gathering space. So you probably see them say, you're not going to see, I don't think it's likely that you're going to see people walking down Main Street smoking marijuana at this point. Go ahead.
So, if I go to so can hotels also ban that? Because I've gone to hotels and I don't like the smell, it just drives me crazy. But I don't like smoke smell either, so. And it drives me crazy, and I would like them to put me on the floor where they're not smoking all that stuff.
Yeah, so any private business can ban the use of marijuana within their establishment. And I can tell you, Joe's comment, I actually am Assistant City Attorney in Fontana and drafted the affidavit. So you can legally, if you own the property and you're renting it, prevent someone from growing in there if that's what you wish to do.
Does that include single family?
That includes single family. We also believe that some HOAs can put provisions in their HOAs so that they're not allowed to cultivate marijuana in the community.
Then there's a question in the back. Question in the back. Blue jacket.
Yes, did Proposition 64 affect the state statute banning the sale and use of synthetic marijuana such as spice?
That I'm kicking to you.
So Prop 64 did not expressly touch on the subject, but my understanding is that those synthetic materials are illegal, and Prop 64 does not address synthetic materials.
One more.
In writing the ordinances for our cities, you could put in there something about how things have to be tested, right? You could mandate the testing and
That's right.
disallow anything synthetic.
That's right.
You need a test, you need a test requirement, you
You-
need something
you'd-
to calibrate against.
That's right, you would have to have a testing facility.
And there are
have-
testing facilities.
That there are testing
Labs.
facilities, that's right.
And there's one more in the back.
Yeah, so I saw some stating that President Trump is gonna pass some federal regulation in regards to medical marijuana. So my question is, how does that affect Proposition 64, if it gets passed?
I did not hear that, so I don't know the particulars of it and what the scope of it is. If it's medical marijuana, I don't know necessarily if it would impact Prop 64, because Prop 64 is directed towards recreational marijuana. It does have language in there that does address medical marijuana, such as you can't use a sales tax against marijuana, but it really, the scope is recreational use for here.
One more question.
One more. Go ahead.
So I have a girlfriend that has an 8-year-old daughter, and they live in an apartment, and the gentleman next door smokes, and the smoke goes straight into their apartment and affects her and her daughter. So what rights does she have to prevent that from affecting her and her daughter and her apartment?
One thing that was an interesting comment, and I'm going to credit Tom with this, is he was saying, you know, in all these lease provisions, there's usually some language that says you're not allowed to engage in any behavior that would be illegal under state or federal law. Marijuana is still illegal under federal law. So technically, the person is probably in violation of their lease, and so if you are a tenant, you could probably complain to the landlord, who should be able to do something about it. In the back, please.
Last question I have anyway. So with alcohol, we know there's regulations on drinking and driving, right? What regulations are there for smoking?
The sound
I
driving
drive
regulation.
He's an
Right.
engineer, I work out in El Segundo. And I drive home on a regular basis, and I get the whiff of this, like somebody just mowed their lawn.
And they're going too slow.
They're going 4 miles an hour.
Okay, so we've actually done this presentation where there's law enforcement in the room, so we've heard some of this, and we knew this. The testing's still emerging, so they have some cutting edge testing that's coming that will show how recently the person ingested, so they can use that, but also officers are trained on reasonable suspicion. So if they pull them over, they don't need to have a test that basically they can, you know, have blow into this and we can measure your THC level. They can basically do the litmus test, stigmas.
I think that
The test where you watch the eyes, you know.
it's a field sobriety.
Field sobriety test. And if they believe that you're intoxicated, they can pull you in, arrest you, and give you a blood test in order to determine whether it's in your system. And that should be sufficient for drug driving. But I think everyone believes that the testing is going to continue to get better and better. And in fact, that's a double-edged sword, because as the testing gets better to determine what level of intoxication you are, then there are going to be more arguments when we get to the employment side, my area of expertise, more areas where employees and employee groups protecting employee rights can say, well, if this is legal on, you know, the public side, the recreational side, and the person is not intoxicated to a level at work where it would affect their ability to perform their job, do you really then therefore have a right to terminate them? And we'll talk about that in just a little bit. But so when that comes, we'll see those arguments start to get raised.
Just
Yeah.
really quick, I didn't know, Kat, here if you said that. I can tell you that state law enforcement agencies are really, are really scrambling to come up with a field test, other than a field sobriety test where you can actually test on the spot. So as this is gaining momentum, law enforcement agencies are looking around and trying to figure out how they can get a test that will actually measure the amount that you have and how recently you consumed it after it's. Because marijuana tends to stay in your system for up to 30 days, there is a concern that if someone just happens to be driving, they have an expired tag, if you pull them over and you test them, they could test positive, but they may not have consumed it for 3 weeks. So they are still trying to develop a test that's sophisticated enough to try and capture the time when you actually consumed it, and whether you actually are under the influence at the time.
And that's exactly right, but hopefully, again, they need reasonable suspicion.
That's
So
right.
if it's been 30 days ago, I presume their eyes are not going to be red and they're not going to be slurring their speech. So that shouldn't be a big issue initially. So let's get to the employment issue, because this is an employer group, so we really want to know what can we do and what are the issues related to employment. So first of all, I need to confess, there's a little guidance on employment issues in Proposition 64. In fact, I'll say this, I believe they probably carved out these issues in response to concerns about employer groups coming up and saying, well, this is going to be dangerous for employers and it's going to really impact the employer's ability to have a productive workforce. So remember, marijuana is still technically illegal federally under the federal system, and that creates an unusual and interesting kind of legal landscape, if you will. So let's talk about why employers are still concerned about drugs and alcohol in the workplace. And I'm always interested, there's all these studies that say what the effects are of a drug workforce. And I'm like, who allows their workforce to get drugged in order to get these studies? But they are out there, the Department of Labor has these statistics. 70% of current illegal drug users are employed. They make up 11% of the workforce. 90% of alcoholics are employed. About 10 million Americans use marijuana, 2 million Americans use cocaine, 6.5 million employees use marijuana, 1.25 million employees use cocaine. Now here, so Colorado in 2014, the year they opened retail shops, marijuana-related traffic accidents increased 32%, 12% fatalities involved those impaired by marijuana. Drug users are 2.5 times more likely to have absences greater than 7 days, 3.6 times more likely to injure themselves or coworkers in a workplace accident, 5 times more likely to be injured in an accident off the job, affecting attendance, performance on the job, and 1/3 less productive. Again, that's the Department of Labor statistics. Workplace substance abuse. Employees tested positive on pre-employment drug tests at the Utah Power of Light. Why they were allowed to get that job afterwards, I don't know. Were 5 times more likely to be involved in a workplace accident as those who tested negative. Drug-using employees at GM averaged 40 sick days a year compared to 4.5 sick days a year for non-using employees. So you can see there's a legitimate reason for employers to be concerned about rampant use, either alcohol use or drug use. So, if it's illegal, can I discipline an employee for using marijuana? As I said before, so I'm not hiding the buck here, yes. So under current law, let's talk about Ross versus Raging Wire. That's the big case in California, employment-based case. And that was under the medical marijuana law, but the prevailing wisdom is that this is also going to apply to recreational marijuana. So in Ross versus Raging Wire, basically it was a person who was applying to a position and he tested positive on a pre-employment drug screen. So he tested positive for marijuana. His position was, and he showed his medical marijuana identification card and his medical issues, he said, I'm disabled and under a doctor's care I'm taking marijuana for, and it was a back issue, for my back issue. So under the Americans with Disabilities Act and under the California Fair Employment and Housing Act and CFRA, the Family Rights Act, you have to accommodate my disability by allowing me to use marijuana. So this was the case that went up. And basically the court said, you know what? No, a reasonable accommodation is never the case that we have to allow something that is illegal, even if it's only illegal on the federal side. Does that make sense? So it's illegal on our state side, but under our employment laws in our state courts, it's still not going to be a valid basis for insisting that you have to allow it to occur in the place of employment. So the claim of FEHA, that's the Fair Employment and Housing Act, for discrimination or failure to accommodate that disability. The court's not focused on FEHA. The Compassionate Use Act did not address employer-employee. It just immunized from criminal prosecution, and other states have included protections for employees. And I think Minnesota and some other states have basically said, hey, if you're using it for medical use, we as a state, we're going to allow you, we're going to force employers to allow you to use that for this treatment. California has not done that. Okay, so here's the issue though, and here's where I think we're going to get a lot of pushback and where things are going to start to emerge when we're talking about case law emerging for marijuana use. So we have a labor code in California, it's called 96K. Labor Code 96K, basically it's authorized the labor commissioner to review claims of loss of wages as the result of demotion, suspension, or discharge from employment for lawful conduct occurring during non-working hours away from the employer's premises. Also, and we're going to talk about this in a second. By the way, are there any public employers over here? Public employees have another layer of rights. So that these two are going to dovetail together, and I believe we're going to see cases before the labor commissioner and before state courts where employees and employee groups are going to push saying this is lawful conduct, at least on the state level, and it is insufficiently tied to the place of employment in order to warrant a termination. So 96K is basically the law. You've probably seen cases before. I'm going to use a bad example from probably about 15 years ago where there was I believe it was a female police officer, and on her off hours, she was a stripper. And then the employer found out about it, and they're like, we're not going to allow this, so we're going to terminate you. Well, under 96K, you can't terminate someone for something they're doing off the job that is lawful. There has to be a nexus or a tie to the place of employment. So if you read that case, the courts actually said, you know what, if she was wearing her badge and her, if her gimmick was that she was an officer, that would be sufficient because it would taint the department, right? So that would be sufficient. So, but it's got to have a tie. Otherwise, it's illegal under Labor Code 96K to terminate or discipline someone for something they're doing off the job that's legal. Now, right now, the prevailing wisdom from the labor and employment attorneys around California is this requires lawful conduct, and it is not lawful on the federal side. So we still have an argument. If they brought the case to me, I would go to Superior Court and I'd say, hey, Your Honor, it's not lawful, and let's go through the federal law that says that it's regulated. In fact, I'll show you the Raging Wire case where they admit that it is not lawful, and employers can really push back on this. I see this, however, as an area that will be challenged in the future as it gets more and more remote. So one thing that we talked about before is that this stuff can stay in your system for up to 30 days depending upon usage. I can see a situation where someone is terminated and for some reason, and it's going to have to be a test case, so it's going to have to be great facts for the employee. They're terminated and it's such low increments, and they can prove they had no reasonable suspicion, the person wasn't intoxicated, and it was only in the system in such a limited capacity that it could in no way affect the place of employment, so there's no tie to employment. You see what I'm saying? And then they push this case. I think, frankly, we'll see more quickly, we will see claims before public employers and or unionized workforces, because they typically have either the National Labor Relations Act or the Myers-Briggs-Brown Act, and there are organizations, so labor boards, that hear issues where there has to be a nexus between the wrongdoing and the work in order to support the discipline. So for a public employee, you can't just terminate, they're not at will, they have due process rights. You have to terminate them for cause. So you have to prove what the nexus or the tie is. So I can see almost immediately that we'll probably have arbitrations, under a collective bargaining agreement, and they call it a memorandum of understanding on the public side, where the union will basically say, there's an insufficient nexus or tie because this person, sure they had it in their system from 30 days ago, or 25 days ago, and perhaps they can prove that. So we're gonna see those, and frankly, I'll say a couple things. So if at ever any point the federal government allows it or changes its law to allow marijuana, the same way it reversed on prohibition and allowed alcohol, these laws are really going to come into effect, and we will no longer be able to push the same way we can push now on employees to terminate and to enforce zero tolerance policies. As it is right now, though, the state of the law is, if you have a zero tolerance policy, you can enforce it. And frankly, not only is it zero tolerance, but if they test and they test positive at all, because it's a positive or negative test, you can terminate for a positive test. Now, I know I get a lot of discussion about, well, it's positive, but it doesn't say how intoxicated they are. Well, my position is this at this point, and I think this is consistent throughout all the labor and employment attorneys in California right now. You can, as an employer, for instance, have a policy that says you may not have alcohol in your system even if the amount's lower than would be allowed by the DMV for driving, right? Everybody's aware of that, right? So I could say, if you test positive for alcohol, even if it's at a 0.2, we can still terminate you because we're an at-will employer, and that's our rule. In the same context, we can have a zero tolerance policy for marijuana, right? So even if they have a low level of marijuana intoxication, it's beside the point from my perspective. You tested positive, it is in your system, it's in your system at work, that's sufficient grounds for at-will employment for a termination. The real issue from my perspective is queuing up the employees to understand that so it's not a surprise when it happens. And we'll get to that in a little bit. I've actually been doing a lot of memos. And so I'm not going to go through these a lot, but I wanted to make sure that you had some of these cases. And by the way, if you want the PowerPoints, these are the emerging cases, the lawful off-duty conduct. Coates versus Dish Network, Curry versus Miller Coors, and then Labor Code 98.6, which enforces 96K. If you search that, you find the cases I'm talking about. Briefly, accommodation. I already kind of stole my own thunder on the Raging Wire case because it's a marijuana accommodation case, but an employer cannot discriminate against a qualified individual with a disability regard to job application procedures, hire, advancement, discharge, terms and conditions of employment, privileges of employment. They must make reasonable accommodations for those disabilities and engage in an interactive process meeting. So the general law is if you know that somebody has a disability, you must do, and I would like a letter that says you are going to have an interactive process meeting with us. That's not required, but it's a good paper trail. And you sit down with them and you say, okay, what are your limitations and how can we accommodate that? You have to do that when it comes to a disability. What's clear though is they don't get to choose their accommodation. So they don't get to throw their medical marijuana card on the table and say, accommodate my pot smoking. That's not going to be a requirement under Raging Wire at this point. So under FEHA, mental or physical disability is one that limits, not substantially limits, but just limits a major life activity. I will say that's broadly construed in California, so almost anything that affects any life activity, whether it's your psoriasis, you've got skin rashes, that's enough, or a leg issue, that's enough. It's very broadly construed in California. Under ADA, it's a physical or mental impairment that substantially limits, so you see we've got greater protections on the state law. In the interactive process and accommodation, if it is an undue hardship, if the accommodation they're requesting or any accommodation is an undue hardship on the employer, you do not have to provide it. The safety of the employees or others is paramount. No obligation to provide the most expensive accommodation and no available positions. So the employer is not required to create a brand new position to accommodate this person's disability. No obligation to accommodate the use of illegal drugs, and that includes illegal on the federal side, even if it is legal on the state side. But be aware of this. So, and I think I said Minnesota, but it's Nevada, Connecticut, and Delaware have state laws that require the accommodation of marijuana usage for medical issues. So hopefully you guys don't have businesses in those states right now, in addition to the ones you have here. If you do, talk to an attorney in Nevada, Connecticut, and Delaware. Okay, so in the interest of time, I'm going to go through this. This really echoes the Raging Wire case, so I'm going to go past this. So, is it illegal or not? Marijuana is still illegal under federal law. Employers can still rely on the supporting policies. Prop 64 has no employee protections. That's the important takeaway. So, I started by saying there's little guidance. I think that's intentional. I think it's an intentional carve-out for employee protections. That means we as employers get to decide. The issue is you need to have good policies and you need to set expectations. You should watch for the cases and changes to the ADA or federal or state law. So if Sessions comes down and he says, we're going to enforce all these marijuana laws, or we're going to require states to enforce it, or otherwise we're going to take funding away, which apparently is something that the Trump administration likes to threaten nowadays, we may see things change. And of course, we'll do webinars or presentations on that if that happens. Okay, and I'm going to pass by the additional cases. New testing, this is one thing that we talked about earlier. There's a marijuana breathalyzer. It's conducted on roadside tests. It differentiates between recently used but not impaired and impaired. It measures the THC levels, and it's 2 hours after ingestion. So really, it's a focus on when it was taken as opposed to the entire THC levels. There's also a saliva drug swab that's up in its way. So these are two areas where we're seeing the drug tests emerge. The saliva drug swab, there's questions about reliability. It's 3 to 6 hours after use, and it can only tell me if there's a cutoff met. So we can look to law enforcement for guidance in developing these new standards. So reasonable suspicion testing, we may still test on reasonable suspicion. Officers will look for indicia of under the influence, which is red eyes, litmus test, or stigmas test. Always mix those two up. The eye test, the roadside test. Specific contemporaneous and articulable observations of behavior, appearance, odors, speech that suggest drug use or alcohol use. And that's under the federal reporter, 49 CFR 382.307. Okay, so here's the thing that I've been doing. This is the number one thing that I think you can do in order to set expectation. We've had some cases where the employees have shown up saying, well, it's legal now, so I'm going to test positive, but you can't terminate me. No, no, no. So if you haven't done this, please set out a memo. I've been drafting these for some of my clients, and some of them have done it themselves and then just send it to me for vetting. But, you know, passage of Prop 64, marijuana use. You know, you basically say, here's what happened, the law came down. However, marijuana is still illegal under federal law. Importantly, however, the passage of Prop 64 does not make it acceptable to be under the influence of marijuana at work. Remember that your company still maintains a zero tolerance policy. And then finally, I think you need to have this. Any employee testing positive for marijuana usage, regardless of intoxication level, will be subject to potential termination. So you cue that up. It may be legal on the state side, you may be able to smoke, but you're still running the risk that if you have a test here at the place of employment and you test positive for marijuana, regardless of when you took the marijuana, we can still terminate you. So, in addition to that, you know, I have typically been recommending that behind that memorandum you attach a copy of your policy. So photocopy the zero tolerance policy. You can provide in-service training and to line level and management employees on how we're going to enforce this. And comprehensive policy should have zero tolerance. State prohibitions, including prohibitions for possessing, consuming, using, testing positive for drugs. And I've been going through, to the extent that I've had to have clients asking me to, reviewing those policies and really parsing out controlled substances and then defining it either with a footnote or within the text itself, including but not limited to medical marijuana and marijuana regardless of its legality on the state level. So I want the policies to expressly say, here are all the drugs that we prohibit, and we are expressly including medical marijuana and other marijuana substances, regardless of how you ingested it. Specifically address prescription drugs, including medical marijuana. Well, it's not really prescription, it's under a medical marijuana identification card. Delineates when testing will occur. Joe? Yeah. Oh yeah, go ahead.
Since the 70s, I've had a policy and a contract with any of my employees that said no alcohol, no smoking, and no drugs on the job site. Is that illegal drugs?
Well, here's the thing.
So I need to spell out the drugs now?
I think you do. First of all, if I had that policy...
I don't even know the names of all of them.
Well, you don't have to spell them out by name, but here's the thing. Illegal drugs, I would still take the argument, I would still make the argument that marijuana is an illegal drug because it's illegal on the federal side. However, your employees are not attorneys, right? And they're not thinking, well, it's illegal on the federal side. So my preference is to cue them up. So I would say illegal drugs, and I prefer the phrase controlled substances. And then I define that to include marijuana, whether issued under a doctor's advisement or not.
Well, I haven't had to fire anybody since the 70s, so.
Well, they probably know you come down with an iron fist, though, right? Rules are rules. Okay. In the back, please.
So, besides being an engineer working in El Segundo, making a drive, you know, smoking grass, right? So I'm also in the Army Reserves, which makes me fall under federal guidance, right? So the federal guidance, I'm also a company commander, right, in the Army. So therefore, if anybody utilizes Prop 64 in the state of California and then comes to work on that particular drill, guess what I do? Transition them out of the Army Reserve. Now, that being said, National Guardists, their direct guidance comes from the actual state. So how does this proposition affect the National Guard soldier versus the Reserve?
Okay, so yeah, I think that that's actually a really great question because you have a state government basically. Typically, and we represent a lot of state governments, I do not represent the National Guard as an employer. However, I will say this, with regard to state governments, you've got the law, but then you also have your policies, right? So under your policies and procedures, it sets out what you can be terminated for, and unsafe behavior is included in that. Even though unsafe behavior is not illegal, maybe it should be illegal. Like running down the hall with scissors is not illegal, right? But as an employer, I can have a policy that says, I'm gonna discipline you and or terminate you for running down the hall with scissors. That's a bad example, but you get the point, right? So I can have a policy that says, hey, you know, marijuana may be illegal, and you know, may be illegal in our state. However, for our purposes for this employment, we're considering it unsafe for whatever reasons, including the statistics that we presented before. We're not going to allow it. So if you test positive here, even though we are the state and we allow it for recreational use, we're going to terminate you. So they can do it. I don't know if the National Guard does. And there's a question over there.
Yeah, while we're on talking about this difference in separation between the federal and the state, recently they had an opportunity to reclassify marijuana and they decided not to. And my question is this: we have a new Attorney General of the United States. If Jeff Sessions came out and declared that we are no longer going to enforce the federal law with marijuana, is that something that he can do by signature, or is there a judicial process to eliminate the federal law?
Right. So I could keep it. Well, I'll add part and then I'll give it over to Victor to give more in depth. But my understanding is this: the Cole memo is a DOJ instruction, so it's about enforcement. They would have, in order to change the law, they'd have to go through the legislature. So.
That's right, that's my understanding, is that if Sessions were to say, we're not going to enforce these laws, we'd essentially have the same state that we're in right now, the Cole memo. As far as amending the laws, that would take constitutional procedure, and we'd probably have to go through the Senate.
So you're going to have to get that the conservative houses in order to pass a law to bring it away. So I don't think that that's very likely at this point to make it legal on the federal side. Is there another question?
The Coast Guard, I happen to know somebody that was in the Coast Guard that tested positive, and they didn't give him a dishonorable, but they gave him a general discharge and sent him packing. And there's one other service that has an absolute no tolerance. I can't remember. I think it might be the Air Force that doesn't have. They have a no tolerance policy. The other services, it's kind of up in the air.
Yeah, that's absolutely right. I think on the employer front, there are, I think the standard is no tolerance at this point. I will say though, we represent a lot of police departments, and I do work with some of the police departments as well, and I've done ride-alongs talking to officers. And it is, the culture is changing. People are using it more and more, and it doesn't seem like it is a priority for many departments right now to enforce, even before recreational use, enforce on small amounts. Go ahead.
I'm just curious as to, I don't know what the policies are for prescribed medications, for example, antidepressants, pain medication, and like Xanax. I know that 1 in 4 people over 40 are on that type of medication. Is that something that employers also have a policy against, that they can tell people they can't take?
Absolutely. So a good policy, and a lot of them don't have this, a good policy should talk about use of legally prescribed drugs. So I usually say misuse of legally prescribed drugs, or use of prescribed drugs, which is where the proper use would render the employee unfit for duty. Because sometimes you're properly prescribed a painkiller because you legitimately have pain, but you're not in a shape to go to work, so you should really be taking medical leave at that point. So if an employee should know that, the doctor should tell them, here's your opiate painkillers, you shouldn't be going to work on these. And if they're coming to work, they have an obligation to tell you, and if they test positive for either the misuse of the drug, even if it's lawfully prescribed, or the use of a drug that's prescribed, but where the person knew that they shouldn't be able to perform their duties, that's a disciplinary item.
Could it work against an employer who maybe was stricter on the marijuana versus the prescription? Would that be a discrimination type thing, or would it be okay for them to say, yeah, you can drink, but no, you can't do prescription? Or is there any, do you have to be like all of them, or?
Well, let's be clear. The short answer is no. I don't think that we would get any kind of claim for discrimination between the various different kinds of intoxicating substances. But I want to be clear too. Medical marijuana is not a prescription. It's a medical marijuana ID card. Yeah, it's a recommendation, so it's not the same, and it's still illegal on the federal side. So I think it's perfectly appropriate, and it makes sense for many employers to say, okay, we're going to take a more cautious approach to prescribed drugs for legitimate, medical issues, but medical marijuana, we're not going to do that. And that's a policy issue, whether that's appropriate or not. That's something that might have to be hashed out on the governmental side in the federal legislature at some point.
That would be That would be very difficult, because I'm in the construction business, and I can't even imagine, having Cal OSHA come in with somebody that's handling heavy equipment and saying, well, it's okay if you smoke a joint. Yeah, that isn't gonna happen, or up on the roof, putting a roof on or framing, no, can't happen. So Cal OSHA would be on our, believe me, they would be on us like white on rice.
And that's a really legitimate point, and by the way, I will say I do OSHA appeals, especially when you're talking about construction, and 3 serious OSHA citations, so you could potentially get your license pulled when you're doing that kind of manual labor. So I'd have big concerns. And I hate to say it, this is gonna sound a little cheeky, but I'll say it anyway. I call it cockroach theory. If you see one on the floor, there are 100 in the walls. So when my basic take is when you see misconduct and you're wondering whether to discipline, that's the one you caught. That doesn't mean that it hasn't occurred before when you're talking about drug use, etc. And use of intoxicating substances at place of employment. So again, back to policies. Described procedures allow for searches, encourages voluntary admission of a drug or alcohol problem, complies with state and federal requirements pertaining to a drug-free workforce, alerts employees to the possible involvement of law enforcement agencies. I like to see something that really sets the expectation that there's no reasonable expectation of privacy in the place of employment. I think you need to do that if it is your intent ever to do searches in those spaces. And I know we went through quickly, but I wanted to make sure that we had plenty of time for questions. Questions, please, go ahead.
I have marijuana on my bucket list. I've never tried it. I'm allergic to iodine. I can't have any crabs or lobster or anything like that. Is there any test I can take to see if I'd be allergic to marijuana?
Ooh, that'd be a medical. Victor, do you know of any tests? Okay, the question was this: is there any test I could take in order to determine whether, before I try it, whether I'm allergic to marijuana? Do you know?
Yeah. I'm not aware of any tests you could take in order to determine whether you are allergic to marijuana.
There are people that are allergic to marijuana.
Yeah, I believe that there probably are people who are allergic. I guess I would talk to my general physician and walk through the steps and see if there's somebody. As far as I know, there's no allergy test.
Although, don't they have those allergy tests where they make a grid on your back and they put a bunch of stuff? Yeah, you just have to bring them some marijuana. So go ahead and try it out, see if that works.
Just smoke it.
Any other questions? There's one in the back, please.
I know you guys suggested setting an in-house memo as far as what we don't want. Does it have to be added to the actual policy, like handbook, in order for it to stick?
I would like to see 2 things. So first of all, if you were my client and you were saying, well, what should we do? I would say immediately do the memo, attach your zero tolerance policy, and let me see your policy. If your policy hasn't been updated in a while, you want to make sure that you've got a good zero tolerance policy and that it somewhere clarifies the controlled substances that are being prohibited include marijuana, whether they smoke it legally on the state level from Prop 64 or medical marijuana. So I like that. There's other things that I think sometimes are missing in those policies, but I don't need to go into too much depth. Any other questions? And now we're going to turn down the lights and turn on some Pink Floyd for these.
Yeah, and actually, Russ, you want here, let me get some here. Just, we had a request from our mayor to be able to clarify what the current policy or what we're looking at for the state of Superior is.
Does anybody want to hear what we're thinking about doing? I thought you might want to with all this. I have to be real careful because we do have a Brown Act and we can't discuss a lot of things outside the public hearing. But I can give you some general stuff about our colleagues and what I think they're looking at and stuff. One is, I would say, I don't think there's any appetite whatsoever for recreational marijuana use in the city of Superior. Okay, I don't think there's any. I don't know of anybody that is looking at it, but I think everybody's gonna be open-minded and listen to all the arguments and stuff, and then make up their final decision. On the medical side, however, there are some empathies on that, because there seems to be some legitimate uses for medical. Not that you have a hangnail and you have to go get stoned, okay? Now, but there are people, especially in the older generations, that can't take the narcotics and they're in pain. So do we want to make them criminals in their own city? I don't think so. So I think there's some debate going on and stuff, and we're going to hash all that out on the second meeting in March. We're going to have a meeting and we're going to discuss both sides, medical and recreational use, and make a decision and give direction to staff on how to write an ordinance and what we want to see in the ordinance. So I don't think there's anybody that's going to go towards the recreational use. I don't see it. But on the medical, there is some empathy for that. On the delivery side, that's a tough one because they're public roads. Even though it's illegal federally, the state allows it. So can you stop somebody from delivering using a public road? And the way we read the proposition is you cannot stop them going through your city. You could stop them from stopping in your city if you wanted to have a zero tolerance. Okay, so they left it up to us totally right now, legally, to the cities for zoning and stuff like that. So we can make some determinations. And you're going to see a wide variety of that in California and cities. Some cities are going to have absolutely zero tolerance whatsoever. And then you're going to have other cities like, I think, Paris, Needles, Atlanta, that are going to be wide open. Okay, so it's going to be all over the map. And I guess one of my questions that I would have is what happens to all these laws? Because where I hear now, there's a medical marijuana caucus. Or not a medical, but a marijuana caucus in the federal government. Okay, what happens when they change the law? Because it's 26 states now, majority of states. What happens when it becomes all 50 states? If it does, or say 45 states allow it legally. If the feds make it legal, now we don't have that conflict. That's now going to throw it again into another wrench. And they put it down to a Schedule II drug as opposed to a Schedule I, which means they can do research and a lot of different things. So we're still in flux with this. And my opinion, as a public official, is to take baby steps on whatever you do. Okay, I have a personal bias on some of this stuff, but I'll wait for the public hearing to say what I think about a lot of this stuff. But it's real hard, so it's a tough thing because in San Bernardino County, only 4 cities in the county did not approve Prop 64. The unincorporated area was the highest approval. The only cities that didn't approve it were Loma Linda, Upland, Chino, and Chino Hills. Every other city, the populations voted in favor of Prop 64. So it puts everybody in a weird situation. I know as employers and myself, you know, we wonder, you know, gateway drugs and all that stuff, and what, you know, I have grandkids, so I don't want my kids around it and all that stuff, or my grandkids. But as society moves in a certain way, it puts everybody in a dilemma in a box. We do live in a democracy, and if the majority of people want something, what do? But I don't think we automatically go that way either, because there are minority rights too. That's really what a lot of the Constitution was. And that's why we're not a direct democracy, we're a republic, because they didn't want it to be the tyranny of the majority. They wanted minority to have minority rights also. So it kind of puts us in that balance in a sticky position, but we're gonna have the meeting on the second meeting in March, and we'll give direction, so. But I don't know if anybody has any questions about what the city's looking for, or anything, too, in addition, if you could ask that one question, if the feds change.
I'll do that, and I'll throw one other thing in, because I failed to mention this, but if you're gonna, if you're gonna update your policies, one other thing that I've been updating as well is look at your anti-smoking policies in your place of employment. Although it makes sense that anti-smoking would prohibit marijuana, I've been updating them to include all recreational inhalants. So not only medical marijuana, but there are people, vaping is a new thing, e-cigarettes, and people are smoking things that are not really tobacco products. And you want your policies to expressly address that as well. But let's kick it back over. There's questions about the city issue or about the presentation. Go ahead, please.
A quick comment, real quick, Mayor. So basically, if the majority, what you just stated, is that the majority of the citizens in the city of Hesperia voted to pass Prop 64, but for obvious reasons, you want to kind of push back. What financial implications does that have to enforce it, whether it's medical use or recreational use? Is that going to increase taxes? Is there going to be increased?
Well, we have total control. The way they wrote it is we have total control on what we want to do. The problem is, if we, let's say, I'll give an example, let's say we don't allow recreational and it's only medical, you can't tax, my understanding is you can't tax the medical side, there's an excise tax that goes, the state gets its pound of flesh, okay, no matter what. But if you don't allow, if you don't go on the recreational side, you can't get any taxes. So there's no real benefit or anything to allow anything either way, so you're not gonna get any taxes.
I guess what I'm saying is it not going to cost the citizens more to enforce?
Oh, absolutely.
So-
It's just like anything else. You're
But
good.
my question is this, up here in the high desert, all of us are citizens here, we all are business here. There is a massive shortage in law enforcement in our area. I mean, I live in one of the best neighborhoods up here, and we have B&Es all the time.
Well, it's just like anything else. We're gonna have to set priorities on what we wanna do.
Actually, that's the main focus.
We're gonna have to set our priorities on what we want our wanna do.
We really appreciate our elected officials being such great supporters, but we brought our attorneys all the way up from Riverside, and these guys are common targets. You'll have a public hearing. So I just ask you, please, no more questions about the politics of it, just because I don't want to put our elected officials in a position where they don't feel welcome here. They're not here to be drilled. But our legal...
Thank you. And I think there's a question regarding the law back there.
As far as the taxation goes, and correct me if I'm wrong, my understanding was that even on the medical side, there is that 8% tax that I'm currently paying to the Department of Equalization for anyone that just has a recommendation versus the county card. So, correct me if I'm wrong, if you have a county card, I don't charge the patient's tax, the members. If they have a recommendation but not a county card, I'm charging them 8% tax, which I'm paying
That's right.
taxes on. So there are taxes on medical, correct?
There are taxes, that's correct.
Okay.
And you can have an excise tax if you have medical marijuana, what you cannot have is a sales tax. So if someone comes in, they have their medical ID card, you allow a dispensary, they go in there and they pay for, a gram of honey oil or the plant, you cannot get a sales tax off of it. But you can have a business license tax.
Right, to help offset the
That's
cost
right.
of the new law enforcement.
So does some of that tax go to the city?
On the excise tax with the business license, that would.
Yes.
And because there's no sales tax, there's no money to be
Right.
had.
Well, and my understanding, question we'd had before was, well, then what's the impetus to use recreational marijuana as opposed to medical marijuana? But my understanding, and please feel free to chime in, Victor, is that for medical marijuana, you have to go register and get a card. And so there's still enough of a stigma where a lot of people who might be interested in trying marijuana would not be interested in putting their name down somewhere on a registry. So there's going to be a lot more interest in the recreational side. There's a hand there.
Is there a portion of the tax, recreational or medical, that goes towards law enforcement?
So I touched on this a little bit briefly earlier on. So if you permit commercial uses in your community, there are grants that are available through the state, so when they're collecting all this money for the cultivation dispensaries, they take a pot of that, and then if you allow some commercial uses, they'll give, you can apply for grants, and it offsets costs for police, fire, other community
And how long are
benefits.
those grants good for?
They haven't released them yet. That comes out on January 1st, 2018, so we'll get more information on that.
I want to make the question clear. So, medical marijuana is not taxed. We don't make any money, or government.
Under ALMA, which just passed on November 9th of last year, they carved out, you cannot charge a sales tax for a commercial transaction related to medical marijuana.
So the citizens will only benefit if it's recreational, is that what you're saying? From the tax?
For local communities, yes.
Is this regulation or employment? Go ahead, what's your question?
Good morning. The question is, I read something in the Daily Press, and I'm sorry if I misread it, but they said they're gonna get a grant for Atlanta was gonna get a grant from the feds to build a building for BBC to do research.
That is not true.
Eric didn't explain it, what was it I read?
No, that's what you read, it's just not gonna happen.
Yeah. So, is that gonna happen or not gonna happen? I mean, how can they, if it's illegal for feds, how can they build a building?
If Atlanta can do whatever they want, their own money, they're called general funds, as long as it's legal. Now, whether or not they're doing that is it's like a city, but they're not getting federal money for BBC.
Marijuana.
It's not legal. Yeah, that's
Yeah, I can definitely say that. Anytime that you're gonna hear money associated with marijuana coming from the feds, just shut your ears and happen.
The whole block grants usually have an application process, so I'd be very surprised if something like that. Go ahead, please.
Yeah, just real quick. So if people can freely smoke it in their residences now, is that correct?
That's correct, yes.
Okay, so, I'm texting with, my business partner, and he lives in an apartment complex in Los Angeles. The house behind the apartment complex is getting a lot of the, residue fumes. There's nothing he can do about that?
Well, that's not necessarily true, but I think we're going to go into a different area of law because there's plenty of case law on what's called trespass. So there's all sorts of case law where, for instance, someone's got a broken water main and it goes into the adjoining property. So I imagine there can be a cause of action for trespass if there's so much smoke. Nuisance, yeah.
Okay.
So they're going to have to, do that old college dorm trick of rolling up their towel and putting it underneath the door. Go ahead.
Apply a tax on medical marijuana? Can the cities ordinate a tax?
So a city business tax, Victor?
You can have a city tax tied to the business license of medical marijuana. You cannot have a city-based sales tax on the sale of medical marijuana.
You can do an excise tax.
You can do an excise tax.
There is
You can also do what other cities are doing, for example, Fontana is because indoor cultivation is legal. Some of the ways that they've tried to recapture some of the enforcement costs, which I think one of the gentlemen here raised, is we have drafted an ordinance which is called a RIMC, it's a residential indoor marijuana cultivation permit. And what you have to do is essentially go to the city, prove that you have the right, if it's a landlord-tenant relationship, that you have the right to grow indoors, and then what we do is we would process it, and there's a fee associated with it, which recaptures the cost of going in and inspecting the property, the processing of a live scan if you want someone to do that, the police time to go in and inspect the property. So there are ways to recapture costs and try and control the expense related to this use, but again, no sales tax on medical.
Victor, while you're on that, because I'm interested, what's the enforcement? So what's the teeth to the RIMC?
So the teeth to the RIMC is typically, it's a code violation, so you'll have a misdemeanor, some penalties associated with that, and let's say if you are allowed to grow 6 plants, if someone's growing like 18 plants, they can confiscate that, you can have your license revoked, your right to grow indoor for a period, a 6-month period or so, it just depends on how you want to tailor it. I mean, I've seen a wide range.
Go ahead, please.
What are the current laws, you see a lot of tobacco lounges and cigar lounges nowadays. What are the current laws pertaining to the state where, could they add in, recreational marijuana in those sorts of
Amsterdam
lounges.
style coffee house?
Yeah.
So again, it just depends on what the local zoning is within the city and where it is. In theory, they have, I think there's actually language that kind of discusses in theory a marijuana cafe. And so what they say is you can have those type of establishments, but they have to be shrouded from the public. So it's not a plain view. You can't be walking around and just see people smoking marijuana. So you have to have some enclosure related to that.
So if it's an inside and they have the.
Inside or even in a backyard, if you've got like say a 9-foot wall where you can't just see from the street, you could in theory have a marijuana cafe if it's permitted in the city.
In the zoning. Don't hold your breath.
Kind of like a little speakeasy, right?
Don't hold your breath.
Further questions about marijuana? Anybody? Okay.
Can we just make one announcement?
Yes, of course. Yeah.
I want to say thank you to everybody for coming, and I would also recommend, to the extent that you want more literature or more information, our firm has done a series of webinars. Joe has one online where he's actually got the webinar and the slides on there. We have general land use regulation PowerPoints and slides on the website, so it's bbklaw.com. If you go on there on the homepage, there's a link there to the marijuana uses, and you're free to access that information, and you're also, of course, free to contact either of us.
Hey, what size are the marijuana plants? Do they go to?
They're like corn stalks.
Yeah, they can go up to 6 plants about my height. And I never thought we'd hear our attorneys say, go to our marijuana section on our website. Thank you all. You guys all have been a great, fantastic group. I'm going to turn it back over.